If a convicted felon is not able to possess a firearm, then what can he or she use to defend themselves or their family from an armed attacker who breaks into their home? If you or someone you know is a convicted felon, you're probably going to want to stick around and watch this video. Hello everyone, and welcome to the Firearm Firm channel. I'm attorney James Phillips, a former prosecutor and founding partner of Katz & Phillips PA, also known as the Firearm Firm. While it is common knowledge that under the current laws of the United States, a convicted felon is prohibited from possessing any kind of firearm, there is a lot of confusion as to whether this ban also applies to black powder firearms. Well, at the time that Second Amendment was written, it was black powder firearms that were used to secure our nation's independence, and it was these very firearms which the founders would have envisioned when writing the Second Amendment. Now, obviously, both firearms and firearms regulations have changed massively since the Bill of Rights was written. So how does the modern prohibition on felons possessing firearms interact with these older types of weapons? Federal law defines a firearm as any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, or any destructive device. Such term does not include an antique firearm. This definition alone may have included black powder firearms, but a later portion of the statute actually exempts most black powder firearms from the definition. Under 18 U.S.C. 921 subsection A16, the definition of an antique firearm includes any firearm, including any firearm with a matchlock, flintlock, percussion cap, or similar type of ignition system manufactured in or before 1898, or any replica of any firearm manufactured in or before 1898 that is not designed or redesigned for using rimfire or conventional centerfire fixed ammunition, or uses rimfire or conventional centerfire fixed ammunition which is no longer manufactured in the United States and which is not readily available in the ordinary channels of commercial trade. The federal definition of antique firearms also includes any muzzle-loading rifle, muzzle-loading shotgun, or muzzle-loading pistol which is designed to use black powder or a black powder substitute and which cannot use fixed ammunition. For purposes of this subparagraph, the term antique firearm shall not include any weapon which incorporates a firearm frame or receiver, any firearm which is converted into a muzzle-loading weapon, or any muzzle-loading weapon which can be readily converted to fire fixed ammunition by replacing the barrel, bolt, breech block, or any combination thereof. Fixed ammunition is ammunition that consists of a casing that contains a primer, a projectile, and gunpowder. However, be warned that some black powder weapons may not qualify for this definition. If the weapon incorporates a firearm frame or receiver, any firearm which is converted into a muzzle-loading weapon, or any muzzle-loading weapon which can be readily converted to fire fixed ammunition by replacing the barrel, bolt, breech block, or any combination thereof, it will still be considered a firearm, and a convicted felon cannot possess it. In simpler terms, the black powder firearm must not be readily capable of being made into a gun that fires fixed ammunition by replacing any parts just mentioned. If the firearm can be easily and readily converted in this way, it is no longer an antique firearm, and once again, a felon cannot possess it. Well, what does Florida law say about this issue? Florida defines the phrase antique firearms to be any firearm manufactured in or before 1918, including any matchlock, flintlock, percussion cap, or similar early type of ignition system or replica thereof, whether actually manufactured before or after the year 1918, and also any firearm using fixed ammunition manufactured in or before 1918 for which ammunition is no longer manufactured in the United States and is not readily available in the ordinary channels of commercial trade. This definition clearly includes any firearms actually manufactured prior to 1918, and it also includes replicas of these type of firearms. This definition would allow felons in Florida to possess black powder firearms as long as it is made prior to 1918 or is a replica of a firearm made prior to 1918. However, if the antique firearm is used in a crime under Florida Statute 790.001, it will then be considered a firearm for purposes of sentence enhancement. Lastly, be sure that the firearm meets the definition of replica in that it uses the type of ignition system described in the law, and it has not been changed or modernized in any way that may make it meet the definition of a normal firearm. I do want to point out that although Florida law uses the date of 1918, federal law uses the date of 1898 for purposes of when a firearm was manufactured. So, if you want to be in compliance with both Florida and federal law, the firearm must have been manufactured in or before 1898, or the replica is of a firearm manufactured in or before 1898. If you are a convicted felon or a prohibited person living outside of the state of Florida, be sure to check your state laws before possessing a black powder firearm. Be sure to let us know if you have any questions about this video or any other Second Amendment related question down in the comments section below. Also, if you enjoyed this video and have not done so already, please take a moment to subscribe to the Firearm Firm channel by clicking the subscribe icon located down in the right hand corner of this video. Until next time, stay armed and educated.